مساء الخير عليكم. Good evening, dear colleagues, ladies and gentlemen. It's a great pleasure and honor for me today to moderate this important seminar among the activities of the Wednesday one of the Egypt branch of the Chartered Institute of Arbitrators. Some would ask, today is Tuesday, it's not Wednesday. Yes. But as one of our distinguished speakers, Maître Jean-François Legal, he's traveling, so we decided to make it today, Tuesday, before his departure, and so we can seize this opportunity of his presence in Egypt to address the Wednesday one today. It's a real pleasure and honor for me to moderate this important seminar today in view of the subject, which is very interesting and important, and in view of this distinguished panel of speakers that we are hosting today at the Egypt branch of the CIArb. The topic that we will address today is international arbitration trends in 2023 in Africa and an African perspective, what is now and what is next. Our guest speakers today, first, Monsieur Jean-François Legal. Jean-François Legal is a partner at Pinsent and the Honorary Secretary of the Chartered Institute of Arbitrators, London branch. His practice focuses on international arbitration and multi-jurisdictional proceedings, frequently with a link to Africa and the Middle East. He has been praised in legal directories for having built a fantastic African Middle East practice. He is qualified in several jurisdictions as barrister and avocat au barreau de Paris, and registered legal practitioner with full rights of audience before the Dubai International Financial Center courts. He acts as counsel advocate in English and or French in international arbitration proceeding. He also sits as an arbitrator and has acted as chairman of an arbitral tribunal, sole arbitrator and co-arbitrator. He also lectures in arbitration in Paris Bar School, comparative international dispute resolution at Dauphine University in Dauphine, Paris, and English contract law at Dauphine University in London. Secondly, I'm pleased also to have with us today Mr. Girgis El-Shahid, who is the managing partner of Shahid Law Firm. He is specialized in dispute settlement with a particular focus on energy-related disputes, investor-state disputes, mergers and acquisitions, corporate and commercial agreements, joint venture agreements, banking and finance, security offerings, telecommunication, and intellectual property. Mr. Girgis El-Shahid is renowned for his special expertise in complex multi-party arbitrations. He is also recognized for his knowledge in handling all types of corporate and commercial disputes, from routine matters to large and complex multinational arbitration. He is identified among the world's leading arbitration practitioners. Mr. Girgis has been appointed by the ICC World Council as a member of the International Court of Arbitration, serving a second 3-year term beginning July 1st, 2021. He was also appointed as a member of the advisory committee in January 2021. His expertise is built on solid ties to both the academic and the business communities, and he regularly publishes articles in various fields of practice and is a regular panelist and speaker in many local and international conferences on arbitration. Mr. Girgis El-Shahid is a former public prosecutor and has received an LLM in International Legal Studies from Georgetown University Law Center, USA, an LLB from Cairo University, and a BA in Economics and Business Administration from the American University in Cairo. Lastly, but not least, our host, Dr. Ismail Selim, the director of the CRCICA, the Cairo Regional Center for International Commercial Arbitration. He is our host because the CRCICA is the host of the seat of the Egypt branch of the CIArb, and because of Dr. Ismail Selim and the distinguished team working in the CRCICA, we succeed to manage to have these events every first Wednesday with the Egypt branch of the CIArb. Dr. Ismail Selim is very well known for almost all of you, but nevertheless, we should say that he is carrying a very large and impressive both academic and practical CV. He is actually now the director of the Cairo Regional Center for International Commercial Arbitration, CRCICA. He is the president of the International Federation of Commercial Arbitration Institutions, IFCAI, and the vice chairman of the Egypt branch of the Chartered Institute of Arbitrators, CIArb. As far as the academic and teaching history, Dr. Ismail Selim graduated from Cairo University with an LLB, where he also obtained an LLM in International Business Law from the IDAI in 1999. He then earned his master's degree in public administration from the ENA, École Nationale d'Administration, in Paris. By the way, as I served as ambassador in Paris, I would say that anyone who graduates from the ENA in France, this is the first step to open a lot of doors for him. And it is considered to be a very distinguished honor, the persons who pass the ENA. He also graduated of a certificate of International Commercial Arbitration from Queen Mary University in London, and he accomplished his internship program at the ICC Court of International Arbitration and earned his PhD from Université Bourgogne in France. Dr. Selim is also a member and accredited lecturer of the Chartered Institute of Arbitration, CIArb, and an accredited mediator of the London School of Mediation. He has published numerous research papers and articles for international Egyptian foreign review in law, business, and arbitration in English, Arabic, and French. Dr. Ismail Selim also taught private international law and alternative means of dispute settlement at the Institute for International Business Law in Cairo since 2011, and commercial arbitration in Arab countries at the Sorbonne University in Paris. He also teaches international trade law and arbitration at the British University in Egypt. Actually, a career full of accomplishment in the academic and the practice fields. Dr. Selim was co-founded Noor and Selim law firm in association with Al-Tamimi and Company. Before being nominated as director of the CRCICA. He was, before this, also an advisor to the CRCICA before being nominated by the advisory committee in 2016 as a director of CRCICA. Dr. Ismail now is serving his second term as director. He is constantly appointed as presiding arbitrator, sole arbitrator, co-arbitrator, and has acted as counsel in various ad hoc and institutional cases under various international institutional rules and in the fields of tourism, hotels, construction, telecommunication, natural gas, sales, contracts, company contracts, leases, and as they say in French, et j'en passe. It's very long achievements. Dear colleagues, ladies and gentlemen, now we will come to the topic. The topic that our panel will discuss today, as I mentioned, is the international arbitration trends in 2023 and African perspective. What is now, what is next? Under this, we will have a look on what to expect, main drivers of dispute, increase in intra-Africa disputes, what we learned from the recent SOAS survey. By the way, it was in the announcement for this seminar, the link to the SOAS survey and to the second survey from the Queen Mary and Pinsent Manson's survey. I don't know if any of you have got the time to have a look on it, but in a nutshell, the SOAS survey is tackling everything about arbitration in Africa and what are the consequences of things like COVID-19, what are the effects of the quarantine in the field of arbitration, like online hearing, virtual hearing, virtual procedures, the effect of climate change, all what is affecting our world these days. The other point is the increase in energy-related dispute, and this is referring to the survey done by Queen Mary and Pinsent Mason's survey, and this is focusing on the field of energy and energy disputes, and I believe this is one of the most important issues as we speak today due to the international political scene that we are living. Its consequences on, especially in many fields, but especially in the field of energy, sanctions, embargoes, even new trends of sanctions like putting ceilings for products and other things related to what is happening on this our international scene today. Secondly, how to anticipate, how to manage the current upcoming investment risk and how to make it a legal opportunity, drafting lessons learned from the past year to address the future, force majeure clauses, imprévision theory, etc. And finally, we will have the Arbitral Institution point of view. As I mentioned, all these topics are extremely important, and in order to give time for each speaker to express his different points of view, I would ask the colleagues, speakers, if they could stick to 20 minutes each one in order to manage to have some time for comments and Q&A after this. Thank you very much for your attention. And now, with great pleasure, I give the floor to Monsieur Jean-François Legal.
Like this. Great. Good evening, everyone. Thank you very much for the very kind introduction, Ambassador. It's a real pleasure to be with you today. I'm was very moved to learn that you had to move the day of these kind of events for me. So I hope you will not regret it too much at the end of my presentation, but I will do my best. So it's a very easy way, actually. I have a very easy task today because I'm going to actually use the work of others, meaning 2 surveys which have been prepared by colleagues and which I'm going to try and give you an overview of during my presentation. The first survey, as explained a moment ago, is the SOAS survey, which focused last year on different topics involving arbitration in Africa. I will try and focus on some of the main findings, one being the prominence and rise of infrastructure and energy disputes, which will be a perfect transition to the second part of my presentation, which will focus on the survey which has been issued a couple of weeks ago, and which is a survey led by Queen Mary, University of London, and Pinsent Masons about the future of energy arbitration. So starting with the beginning. So the SOAS survey is the 3rd edition, which has been done last year. As was very well explained earlier, this 3rd edition was meant to focus on a number of topics, such as the impact of COVID and others. But for the purposes of today's presentation, and to try and speak less than 2 hours, I will essentially focus on one of those aspects. Just to give you an overview of the survey, it's been published in 4 languages. The questionnaire was prepared in 4 languages. There were 200 responses almost, or 194 to be fully precise, which were received from 24 African countries. I think there were actually 52 respondents from Nigeria and 28 from Egypt. So Egypt was top 2 in terms of respondents. So well done. And I'm sure some of you, actually some of the respondents, may be in this room. So feel free to jump in at a later stage. So that's the graph. As I said, so there were a number of findings, obviously, as a result of the survey. One I would like to insist upon for the purpose of today's session is the rise in terms of infrastructure projects and infrastructure disputes. Apparently, it seemed that there were 132 respondents who explained that they have been involved in construction or infrastructure projects and disputes in Africa, which is a big chunk of the 200 respondents of the survey. 89% of those people expressed the view that infrastructure disputes were on the rise. So I think we can clearly say it's a clear majority, 89%, not too bad. So of course, this is an important finding. Now, I'm always keen to try and back up those kind of empirical findings with concrete data. And obviously, concrete and solid data means CRCICA data. So I had a look at the caseload from CRCICA last year, but of course, I will leave it to Ismail to elaborate further a bit later. But I think this idea of the prominence of infrastructure disputes in Africa is something which, unless I'm mistaken, is confirmed by the CRCICA caseload. I think there was 17% of the cases last year in CRCICA which were construction related, and 7% oil and gas. So if you add up, it's 24% of energy and infrastructure disputes. So by far, I think the first topic, the first category of disputes. In terms of why actually we saw that increase, we saw that rise, or we saw this prominence, of course, there are different factors which can explain that. Some relate, I think, to the level of FDI, foreign direct investments. If we look at other reports, such as the Deloitte Africa Trends report, it referred to the fact that there were 462 projects ongoing in Africa in 2021, I think, for a total value of 521 billion. It's a 20% rise compared to 2020. I don't think we have the 2022 data yet, but still, obviously, this increase in terms of investment means more projects means more disputes means more happy disputes lawyers, of course. Now, so this is one of the findings of the survey. There are others, but in the interest of time, I will just maybe keep that for the Q&A session. Prominence of infra and energy disputes, which is again a perfect transition to the second part of my presentation, which relates to another survey, which is about the future of international energy arbitration, not less than that. So just a few words about what the survey is about. So it's a survey conducted, as the name suggests, by academics from Queen Mary, by people from Pinsent Masons. It's the third time Pinsent Masons collaborates with Queen Mary University. And the idea, the focus, is to determine what are the market trends, the main drivers of those energy disputes in the past and over the next 5 years. So how respondents see things going forward, what can happen next. So a bit like using a crystal ball, but in a better way. There were over 900 respondents, so quite a lot. And interestingly, I think in terms of the survey, there were at least 50 interviews, so which means qualitative data, an ability to challenge the findings and to discuss in more detail. The report was published a couple of weeks ago, and the launch event was actually yesterday at Pinsent Masons, London. So you can see it's very fresh as a result. You can even scan the report if you want, but that's for later. So just quickly, in terms of the market trends and the causes of disputes, what I would like to insist upon, first of all, is the usual disclaimer as a lawyer. As a lawyer, we like disclaimers. I would like to present these findings just as a way, actually, of a basis for discussion with the audience, because obviously a number of respondents are from Africa, quite a good chunk, but not all of the respondents of that survey are from Africa. So we'll be very happy, actually, to see whether those findings are fit with your experience as members of the audience and practitioners on the African continent. But in terms of the findings, and there is this very sophisticated graph, which you can see on screen, which I'm not entirely sure I understand myself, so I will try to summarize it in the clearest way possible. So I would like to insist on a few things, few causes of disputes. The first one is price volatility. I think the results of the survey are probably an echo to what happened recently and in terms of geopolitical picture. 14% of the respondents saw that as an issue over the past 5 years. Now this increased to 28%. So you can see that it's a major concern, and people see that as being one of the main causes of disputes in the next 5 years, next few years. For example, so there was one respondent practicing in Africa and Europe who named the example of LNG cargo disputes as, according to her, something which usually is seen as just a purely operational dispute, but which, according to her, being a GC, was just a symptom of contract parties trying to escape a contract which doesn't make sense anymore from a commercial perspective. And in interviews, one theme which came back very often was the idea that one issue which the energy sector is going to face in the coming years more and more is the fluctuating cost of raw materials, of the input, which you need, of course, to implement, build, create your project. So that's one big chunk. The second big thing, the second big finding, I think, of the survey in terms of where we are and where we're heading is the fact that construction of infrastructure itself will keep leading to a significant amount of disputes in the coming years. One reason being, according to the respondents, people who were interviewed, the fact that oil and gas prices being on the rise, we will actually see more investments in developing infrastructure related to that type of energy supply, and therefore more infrastructure means potentially as well more disputes. Thirdly, energy transition. So it's obviously a big theme, greener energy, greener ways of providing power. The finding in terms of what was discussed in the survey was that actually, despite the fact that it's something which is quite in the news, there's less an impression that this will create disputes on a short-term basis. Why that? Precisely because what the respondents are thinking is that those disputes will take some time. So because energy transition will take some time. So disputes will not arrive now, but really more in 10 years rather than in 3 to 4 years. That being said, in terms of the drivers, the feedback received is that the energy transition will force market participants to resort to different types of technologies, different types of infrastructure, and which will make it more complicated to allocate the contractual risk between the business parties. So more, of course, occasions of frictions and of disputes as a result. Also, new entrants into the market, which will make it more complicated and will create a number of situations where you will face competition and therefore frictions and therefore as well disputes. Maybe just another finding, and I will try and maybe conclude quickly. Security of energy supply has been named as an increasing concern by many respondents as well. Of course, in the aftermath of Russia's invasion, some people have underlined in the survey that this should lead to actually a number of previously abandoned fossil fuel projects being restarted and postponing the onset of energy transition projects as a result. As one respondent practicing in Africa mentioned, I quote, "We won't hang up our boots as oil and gas lawyers just yet." So if you're an oil and gas lawyer, you can be reassured everything is fine. Last thing I will mention before shutting up is maybe government political instability. This is another topic which has been named as a top source of disputes. That being said, something which has been named as an important source, but not more than before. So apparently it's going, according to the respondents, this is a factor, a driver for disputes in the coming years, but nothing really substantially different compared to what it was in the past. One example in that regard can be governments willing to take the most of profits made by energy companies, which they see as something like windfall profits, and which they might decide to actually tax as a result, which might lead to tensions and potentially disputes between those investors and between the states. So there are many other factors, but in the interest of time, I will pause there and leave it to later for the Q&A session. One thing which I will mention as well, but just before concluding, is the question marks and the questions it raises in terms of the international arbitration process. But again, I think we can probably discuss during the Q&A session, but all those questions, all those issues around the drivers of disputes will raise the question of whether international arbitration remains the preferred way of dispute resolution, or whether it might face a number of challenges and might face some competition by other ways, such as mediation, of course, but maybe dispute adjudication as well. But I think we can discuss that pretty later, because I see that I've been already far too long. So thank you very much for your attention, and speak soon.
Thank you, Monsieur Legal. Actually, you saved 3 minutes from your 20. Now I would like to invite Mr. Girgis El-Shahid to present his intervention. Thank you.
Yeah, until Yahya gets us the my presentation, I have a confession to make, is that I have been lucky this past 2 weeks, because when I got the reports and I was instructed by the CIArb to say something about it, I found it was actually very informative, very nice. Someone on the panel from Pinsent Masons will be talking about it much better and more awesomely and more eloquently than me. But then I realized that someone there, as we say it in Arabic, but I will say it in English, Mama is praying for me. Okay. I got a WhatsApp from a friend of mine telling me, Girgis, I'm coming to Egypt these coming days. And this WhatsApp reminded me that actually I worked with this friend of mine on one of the biggest energy projects that happened in Egypt. So let's compare that project with what Pinsent Mason has said. And that takes us to question 19 and 22 of the survey done by Pinsent Masons. What are the likely to be the causes of the renewable disputes? Okay, so let me give you a bit of a background. So Egypt in the past 5 to 7 years ago is known to have the biggest solar project, solar farm, as we call it, in the world. It's actually sometimes said to be seen from the moon, okay? And this is what we call, or known to be the Bin Ban solar project. It's near Aswan. It's actually quite impressive. So Bin Ban, to have worked, the government cooperated with the lenders, the financial institutions. It got the most remarkable developers to come and do the Bin Ban site. And this is the purposes of the presentation. It actually comes second, that the interface or interaction between the government and the developers, private sector, comes second to be the issue. And if you see in between brackets, there's 2 very important words to the African nation: subsidies and pricing. All right, how does a project happen of such magnitude? And I'm sure you've all heard and learned about something called project finance. It all depends on getting the money, getting the lending, getting the money from not the conventional banks, but in these projects, it requires the developmental banks called IFC, EBRD, you name a few. So this is, for example, an article that you will find in the Common Terms Agreement of the Financing Agreement for one of the projects that are there in Bin Ban. And it talks about what? It talks about currency. Currency, and the developer, or the borrower in this case, is to indemnify the lender, IFC, EBRD, Agence Française, whatever you name it, in case of any kind of currency-related issues. And if you look at B, it says that the borrower waives any right it may have in the jurisdiction to pay any amount under the financing documents in a currency other than what it borrowed the money with. So, in other terms, you take dollars, you pay dollars. Okay, now comes, how can I pay the money? I pay the money to the lender through the money I take from selling the electricity. So I develop the project, I make electricity from the sun, awesome, renewables, development, everything, you name it. But my main off-taker, the main buyer is the government, Egyptian Electricity Transmission Company. So let's look at what we call the power purchase agreement under this. The power purchase agreement in the Bin Ban concept, and all of this is in the public domain. So, but I'm giving you the snippets of what is there in the contract. And this is called the feed-in tariff program, because this is the program that had the Bin Ban project developed under. You'll find that it is an agreed rate of 8.4 cents per kilowatt. So every kilowatt that I, as a developer, produce and sell to the government or to the Egyptian Electricity Transmission Company, I will be getting 8.4 US dollars. Actually, you are not getting 8.4 US dollars. You are getting the equivalent of that in Egyptian pounds. All right. First issue. Yet the government was actually quite smart and had very good advisors at the time. If you can see that 8.4 is actually on the dollar will not be just converted and paid as is. At that time, they have said 30% of the amount that we will pay you, Mr. Developer, will be pegged to a US dollar rate that back then seemed to have been good. And that is 8.88 dollar to Egyptian pounds. We all know how much is the rate now. Okay, so this is 30%. So this is the first big issue. The second is then 70%, I'll get it, currency, normal CBE rate. Where is the problem here? Find the dollar. Okay, so I get the Egyptian pound, I get it in the CBE rate. At the time, between those past 2 years, the exchange rate was very, very different than what we call in Egypt parallel market, black market, even if you find it. All right. Bloomberg, for example, has mentioned that there has been a significant difference of 14%, but sometimes it was for sure way more. So I get Egyptian pounds, I have to pay my lender in dollars, and I am, as a developer, stuck in the middle. So these are elements and causes of problems that we will be seeing in the coming days, or my anticipation is that we will be seeing them in the coming days unless the economy gets regulated and the dollar becomes available and apparent. I did a small survey between my clients and told them, is this a problem? And the answer was flat out, yes, we are having this problem. Okay. Some people were saying yes, but some others were saying we come secondary after pharma and milk when they source the dollar to those suppliers. But this is a public project, so when we ask for the dollars from the bank, sometimes we're getting there, and the lenders are sometimes nasty, sometimes not. But this was the relationship between the developer and the lender. The developer and the lender, let's call it private sector to private sector. The same situation happened, but in the opposite side. When Benban was being developed, let's say Benban is here, and it's the connectivity, the first line of cables is there. So it has to have some sort of construction between developing Benban and the connectivity. So there had to be a lot of infrastructure work that should have been done here. At that time, the government told the developers, you will share the cost of the connectivity. And this is what we called the cost sharing agreement. The cost sharing agreement said, developers, the cost of the interconnectivity will be $10 million, for example, but we will be charged a maximum of $4 million of that in Egyptian pounds, no problem. All right. But the government, while they were developing it, there was a price inflation, currency devaluation, a lot of problems that happened in there. Do you think the government honored the ceiling that they gave to the developer? There was an amendment to the cost sharing agreement, let's put it this way, okay? So at that time, when the government was facing this problem, an amendment happened. The question is, what will the government do when the developer, when the investor is facing this problem? Now comes the other question that intrigued me, and that's on the M&A activity, because I like that. It used to be my previous practice before moving to the real world, Dr. Selim. M&A activity. And that comes at the very bottom, and I agree with that for sure, and I agree with the respondents in this regard. However, it is actually quite intriguing because it has a significant article talking about changing control in the power purchase agreement. At the end of the day, the government once decided on this developer to develop this project. I want that developer to be the developer I have for a period of 25 years. If they want to change, they have to seek my permission. But, and Tim knows that better than me, the structure for most of these projects had layers and layers and layers of what we call special purpose vehicles. Okay, I'll show you a slide after that. But what is change of control? The definition of that is that it is a change in a person. Person, of course, is juristic person, directly or indirectly. So remember the word directly or indirectly. But here it's small d, small I, directly and indirectly. What does that mean? It's open for interpretation. So this is the common structure that Tim and I have developed when we were working on this project. Okay, here is the project company. This is the company that signed the power purchase agreement. And there is the leader as a grandfather to the project. Okay, imagine a nasty leader. What would that nasty leader do? They don't want to go to the government. Do you think that they can actually do a transaction at that level and EETC or the government would not know? Very possible, very possible. Okay, but they will be facing the issue of whether or not this is a breach of the indirect and direct change in control. So this is another point I think will be an issue of contestation, particularly in the M&A. Or let's not put it this way. Imagine, for example, I'll just name companies like that. Total and wanted to chip in and buy a project, and the seller is company Y. Total is a very good and efficient name and known in the market of renewables. What about if the government said no? Is this a reason for a dispute, or it's just up to the government? So these are issues that we will be seeing in the coming future. Lastly, on this topic, on this survey, was the point on the seat. In relation to energy-related disputes, Paris comes third, and actually Paris was the seat, that was chosen in the power purchase agreement developed in Egypt. And I would say that this was the first time, this was the first contract, at least that I have seen, but I can bet that this is the first contract that happened in Egypt that has made the differentiation between venue and seat. Okay, so here if you look at 30.33, they said held at a venue in Cairo, and then in 4, be seated in Paris. Okay, the first draft of this article, be seated in Paris, full stop. But the lenders, who are very cautious about that, didn't want to end it here. They said, we actually want to explain what is exactly meaning between the difference between venue and seat. And they added that language, whereby, so that the courts of such country, i.e. France, will be the exclusive competent court in case of action of annulment. So they have actually explained what is the difference between seat and venue in the clause, so that we make sure, or the developer is assured, hence the lenders are assured, that nullity courts are the courts of Paris and not Cairo. So here is where the seat becomes important. And I want to show you a distinction, and this is something that is a seal of approval or seal of respect to the Cairo Regional Center, is that the lenders and the developers did not say no about the rules of Cairo or the impartiality of the Cairo Center. They have actually said, CRCICA, no objection whatsoever. But we want to take the rules of the CRCICA, maybe not somehow connected to the seat of Cairo. This is a seal of approval to the center here, and then there's a lot of work to be done for the Cairo courts to get this same seal of approval, international seal of approval. The other survey, and I only have one slide on this, is another stroke of luck for me, another mama prayer, okay, is that Africa, energy, and then very thorough, and then this article popped in my email about the Paris Agreement. Paris Agreement, remember Paris, Trump coming out of the Paris Agreement, then America coming in again, and the like. So this is the most important agreement on climate change and the environmental sanctity. And this is where the ICA is now drafting disputes annex for the Paris Agreement. And I'm quoting here from this article. It's an article in GAR, and it says, the objective is to facilitate the resolution of disputes between the parties without lengthy debates over conciliation rules in order to ensure that the Paris Agreement can make the necessary contribution to the adaptation, mitigation, and limiting of global temperature rise to fulfill its objective for transformative action on climate change. So the role of the dispute body here that ICA is now drafting is to make sure that the ultimate essence of environmental sanctity is preserved and expedited. When I look at the members of the ICA panel that is drafting, I only find that there is only one African person on the panel, and he's not living in Africa. So this is a point of maybe remark that should be given to ICA, that there's a lot of African states in the Paris Agreement, but only one African member that is there on the panel. Thank you very much, and I'm happy to take any questions later on.
Thank you very much, Mr. Girgis El-Shahid, for this very interesting intervention that touches upon matters that we are facing and living day to day these days. Now I give the floor to Dr. Ismail Selim for the last intervention with this panel before going to Q&A after this. Dr. Ismail, please.
Thank you very much, Ambassador. Ladies and gentlemen, good evening. It's a pleasure to be with you today. In light of the surveys of SOAS and Queen Mary of London in collaboration with the Pinsent Masons, which has focused on energy disputes, I will discuss with you what I have seen in the near past, the trends in energy disputes, especially oil and gas disputes that were referred to CRCICA, and what we intend to do in the future. And I will try to relate it with the findings, especially of the Queen Mary of London survey. So I will only speak of CRCICA's perspective. So I have noticed some special features about arbitration, oil and gas arbitration administered by CRCICA compared to arbitrations involving other sectors. So let's start with the arbitration agreement. We regularly find the choice, so usually how the arbitration, how the arbitral tribunal is to be constituted is dealt with in detail in the arbitration clause. And we are lucky to explore that because under the Egyptian constitution, any concession agreement has to be enacted by a law adopted by the parliament. So this is perhaps one of the rare arbitration agreements that you can find it accessible in the official gazette. So this is something you will not find in other sectors, but in the oil and gas and any concessions concerning natural resources, by virtue of the constitution, the agreement has to be adopted as a law and approved by the parliament. So thereby, it will be published in the official gazette. So before the establishment of Cairo Regional Center, traditionally these concession agreements, oil and gas, were the arbitration clause used to refer them to ICC arbitration. And then by the establishment of the Cairo Regional Center, this has changed. And the Cairo Regional Center was the arbitral institution to be chosen by the parties. But we find some special stipulations in this arbitration clause if we go through the different concession agreements, and I invite you to search for them in the official gazette. You feel that there is a sort of I will not say a tension, but a bargaining during the negotiation of the arbitration clause. There was a policy of the Egyptian government to encourage the use of the Cairo Regional Center because it was established to be used by the different users in the Afro-Asian region, for the contracts performed in the Afro-Asian region. So there was a policy behind that, and certainly the EGPC or EGAZ, I don't know if it existed since then, but at least EGPC at that time had a relatively strong bargaining power to invite the foreign investor to agree on CRCICA. However, there is a detailed dispute resolution clause explaining how each party would choose its own arbitrator, and then the two co-arbitrators would have a certain number of days, 30 days, to agree on the presiding arbitrator. And what you find in these arbitration clauses is that in case the two co-arbitrators disagree on the presiding arbitrator, then the PCA, the Permanent Court of Arbitration, would be the appointing authority. And this is a flexibility that is possible if you choose CRCICA rules. You can choose CRCICA rules, but agree on an appointing authority other than the center. This would not be possible under other rules. For example, if you choose ICC, you cannot agree on ICC rules and then choose another appointing authority. That would not work. So that is a trend that we see until now in all the major oil and gas concessions. It's still CRCICA rules. Still the presiding arbitrator is appointed by the co-arbitrators, and still the PCA is the appointing authority in case of failure of the two co-arbitrators to agree on the presiding arbitrator. And this gives comforts to foreign investors in this field who are not well informed or are not aware of CRCICA's neutrality. So they will have some comfort because they would be more familiar with the PCA as an appointing authority under the UNCITRAL rules. And then you will find at the end a provision providing that in case the arbitration cannot be conducted under the rules of the CRCICA for any reason whatsoever, then the arbitration would be governed by the UNCITRAL rules. I believe that this clause still exists. I think there is no reason now to have this fallback provision, but I assume that in the 1980s, the foreign parties were not yet sure whether CRCICA would continue to exist. Because when you choose a new institution that is newly established, there is a risk that perhaps in the future when the dispute would occur, the chosen institution will not exist. And we have seen this, an example in the region. DIFC LCIA was chosen by the parties, and today it does not exist. So now CRCICA is established since more than 40 years. I do not see a reason to for this fallback provision at the end of the arbitration clause to feature, but it is still the template that is still used, and we see a lot of templates when arbitration clauses are negotiated. You will see that the survey has discussed the most preferred arbitral seats of arbitration. So London comes first, then Paris and Geneva, and then Singapore. So Singapore comes second after London, but in Europe, Paris and Geneva also had a good score after London and Singapore. So in this survey, Cairo was not mentioned. In the previous survey, not in this one, Dubai was mentioned as one of the most preferred seats, but it came 9th or 10th after the traditional seats that are usually preferred by the users in these surveys. So comes Stockholm and Hong Kong as the most preferred seats, but usually after Paris and Singapore and Geneva which usually come first. But in these concession agreements, it's usually Cairo and CRCICA. There is a mixture, or in the eyes of the negotiators, usually they do not distinguish between the host state of the institution and the seat of arbitration. So the Ben-Ban case, or the Ben-Ban contracts, constitute an interesting development to distinguish between the host state of the institution and the seat of arbitration. We will not see it a lot because it is a policy that the Egyptian government wants the arbitration to be seated in Cairo, Egypt, but perhaps the dynamics of the negotiations of the Ben-Ban projects were somewhat different. The survey has discussed the reasons of disputes. So the first cause of energy dispute was, as mentioned by Jean-François Le Gall, was price volatility. I would say that from a CRCICA's perspective, after the Arab Spring, the CRCICA has registered its biggest cases ever in oil and gas and in energy disputes. So from CRCICA's perspective, I would add political turmoil. Political turmoil would be a cause of major energy and oil and gas disputes, because when there is a change of government, when after revolutions, there are a lot of dysfunctions, there is a change in government. The decision makers are unable to take decisions. They are undecisive. There is a fear of taking a decision and then to be prosecuted. So obligations are not usually complied with, and courts would annul in existing investment contracts. So this could lead to major disputes. So political turmoil was the cause of cases amounting to multi-billion US dollars that were registered at CRCICA. And I invite you to read the 2021 version of the yearbook, if you have a subscription at Clur. 4 major awards that were conducted under CRCICA rules. They are in the field of energy and oil and gas. They have been published but pseudonymized, so you would not recognize the parties to the dispute, but it is interesting if you wish to have an idea about what was the subject matter, force majeure, etc., the applicable law, because sometimes the English law was the applicable law in these cases, so it was not necessarily Egyptian law. So I invite you to read them if you wish to have an idea about these cases. One special feature also that I have found in arbitration clauses inserted in these concession agreements is that some foreign parties have chosen the CRCICA rules at the time of the agreement. So at the time of concluding the agreement. So this perhaps was due to the, I don't, is it because of the uncertainty of the future of this institution? So we, until very recently, we were registering cases governed by our 1998 rules and 2003 rules and 2007 rules, which are not in force anymore, but chosen by the parties. So we have remedied to that. So of course, as a center, we have to comply with party autonomy, and we have administered the cases based on these rules, our old rules, but our practice, and we have issued practice notes, is that the schedule of fees and the administrative fees of the center and the schedule of fees of the arbitrators that will apply is the current schedules, because the old schedules could not permit the appointment of a Class A arbitrator, because the level of fees at that time is not suitable for the inflation and the value of the currencies now. We see that in these, how much time do I have?
No, we still have
5 minutes? 5 minutes, okay. So sanctions, so the survey has talked about sanctions having a significant impact on contractual performance. It did not deal with how the institutions would deal with sanctions, because this is an important issue. And we see that, for example, Russian parties are looking for institutions that are not located in Europe, because these institutions located in Europe are bound by the EU regulations, which apply sanctions on some Russian companies which are subject to sanctions. So this has, the sanctions did not start only with the Ukraine war of 2022, but there was also a Ukraine small war that took place in 2014. And by virtue of which Crimea was occupied by Russia and annexed to Russia. So the sanctions at that time started. So the Russian companies starting to have difficulties in arbitrations administered by arbitral institutions located in Europe. So they need to have a permission or authorizations in order to permit the arbitration to proceed, especially the payments of the arbitrator's fees and the administrative fees because of the sanctions. And then the Russian parties were called by Singapore, CIAC, to have their cases administered in Singapore. And now Singapore applies sanctions after the 2022 war. So they are still blocked in Singapore. So now they are looking to Dubai and Cairo. So in places like Cairo or Dubai, we are not bound by sanctions that are applied within the European Union or in the USA or in England. Yet the centers in Europe, they lobbied to get an exemption from the European Union in order not to apply the sanctions regarding arbitration proceedings, because it caused issues of denial of justice, not only to Russian companies, but also to the European companies that might be a party to an arbitration against Russian parties. So not only the Russian sanctioned companies would be prejudiced, but also the counterparties as well. So that was an achievement made by the European, the centers located in Europe. You will see in the survey that arbitration was chosen as the most suitable forum to settle energy and oil and gas disputes. So it's still arbitration and nothing else. You can see in the statistics, arbitration is clearly seen as being very suitable for resolving energy disputes, and 72 of the respondents to the Queen Mary survey gave arbitration a score at least 4 out of 5 in terms of suitability. There was an emphasis on expedited rules. There was an emphasis on the importance or the rising importance of third-party funding. So as CRCICA, what we are doing to remain a suitable institution for energy disputes, because these disputes are complex disputes usually, we are issuing very soon our amendments of our rules. So our new rules are going to be issued very soon. They are going still to be based on the ancestral arbitration rules, but we are going to follow all the developments that have occurred in international arbitration during the last decade. So we will not wait for ancestral to develop or to amend their 2010 rules on which our 2011 rules are based, but we are going to insert new provisions regulating consolidation. Consolidation is very important. It's not regulated by the current rules, as well as in the 2010 rules. We are going to introduce a section or an annex on emergency arbitration, because in many oil and gas dispute and energy disputes, you might need to appoint an emergency arbitrator. We are going to have a section on expedited rules. We are going to add a provision for third-party funding, so an obligation on every party to disclose if there is a third-party funder, if there is a third-party funding, and the identity of the third-party funder in order to avoid conflict of interest with the arbitrators. And these issues were mentioned more or less in the survey. I hope you will be all excited about reading our new rules. And finally, the arbitrators' fees. They are going to be, there will be a spectrum, there will be a minimum and average and the maximum in all or almost all the categories of sum in disputes. And this situation is different than the situation now. You will see in table 3, the disputes amounting to more than $3 million. There is a spectrum, while in table 2 of our current rule, there is no spectrum for those disputes that were small in 2011, because in 2011, $1 used to worth 5 point something Egyptian pounds. So a $3 million dispute used to worth 15 or 16 million Egyptian pounds. Now it's worth almost 100 million Egyptian pounds. So a change is needed. The advisory committee will be soon reviewing the work done by 5 members of a small committee that has drafted these new rules with the help of 2 rapporteurs from CRCICA. And you will soon see our new rules, and we hope that they will fit the purpose and will comply with the criteria designated by the respondents to the Queen Mary survey and the international arbitration community as well. Thank you very much. And I give the floor to our dear Ambassador, the Moderator. Thank you.
Thank you very much, Dr. Ismail. It's very enlightening, all what you mentioned concerning the point of view of the arbitration centers, and especially CRCICA. Now we will open the floor for discussion, comments, questions. I would like to ask you, please, first, when you take the mic, to tell your name, what is your position, and to specify whether your question or remark is addressed to the whole panel or to a speaker, to mention to whom you are asking the question. But before this, and I would like to ask this distinguished panel if I could use the privilege of the podium to make a first comment myself. Actually, my comment is based on the SOAS survey, which mentioned something for me, I found it very interesting to comment on. Saying one of the most significant milestones achieved by the African Union is the commencement of trading under the Africa Continental Free Trade Agreement, Area Agreement. It's very important development, yes, but what I'm concerned about is the question that came upon this fact. The question is, do you think we should have an African International Commercial Court to deal with the intra-African cross-border disputes? And here my comment is based on an international legal and diplomatic experience to try to find or to create a court that would have a supranational jurisdiction. That means its ruling, and its ruling will be enforced in any of the member states. Such supranational court, in order to reach an agreement on it, it's very, very difficult, because normally the countries do hesitate very, very much in giving any concessions concerning their sovereignty. And I don't know why we should think of creating a new bicycle, which is difficult to construct and even much more difficult to ride, as we have on the same time the bicycles that we could ride easily. And I mean by this, the African and Asian existing centers for arbitration, which was created under the auspices of the ALCO, the Asian African Legal Consultative Committee, or organization now, in the late 70s. And it started with two centers, one in Africa, the Cairo Regional Center, and one in Kuala Lumpur. Then when the experience was a success one, two other centers are now existing in Africa, plus the Cairo Regional Center, which is the Lagos Center and the Nairobi Center. And in Asia, there is other two more centers, which Tehran Center and Hong Kong Center recently. So I think that if we face a rise in the disputes between the African entities under this agreement of the free trades areas within Africa, I think the best way is to encourage the parties to refer to these existing centers in Africa, like the Cairo Center here, which, as Dr. Ismail mentioned, gained a lot of credibility, especially in view of its status and its seat agreement with the Egyptian government, which gave the CRCICA the full international diplomatic immunities. That means the center is totally independent. There is no whatsoever kind of influence from the government on the center or in this regard. So instead of and trying to create something that we all know that it will be difficult, we should encourage the parties to use what is existing already. Sorry for being long on this matter. And now I give the floor for whomever would like to present his question or comment.
Good evening. My name is Abdulrahman Mahdi, lecturer assistant in the BUE, British University in Egypt, faculty of law, of course. So I have just a comment about the arbitration clause that differentiated between venue and seat, because before associating to the BUE, I was a lawyer, and I remember working on a contract, and one of the reasons we also differentiated between venue and seat in this agreement, as I remember, we had a whole negotiation of 2 hours from a total 20 hours negotiation on the final negotiation on the agreement. We had 2 hours negotiating just the arbitration agreement. And one of the reasons because of which we differentiated between venue and seat was the question, why in your state, not mine? So between the two parties. So why we go to the seat of your state, not mine, and why we go to the venue of your state, not mine? So I'm not sure if this could be a valid criteria, but for the parties, I think they think this way. And we had, for our party's position, we had to make the Egyptian courts like having jurisdiction to rule over the annulment. So we made it the seat, and we went for Dubai Center for the as institution. But the thing I remember, and this is also for the note Mr. Girgis said about CRCICA rules, is that when we were negotiating, and the exact where we said that we choose CRCICA for our position, CRCICA and the seat Cairo, the exact reply from the other party was that they have no issue at choosing CRCICA, but they will never allow us to have both Cairo Regional Center and Cairo courts having jurisdiction. So we had to give up on the CRCICA rules, unfortunately. Sorry, we had to give up on it. But they clearly said that they would like to have the CRCICA rules, but another state as a seat of arbitration. However, the negotiation ends up in the bus because we had to do it. But again, the point is that I think one of the reasons of this distinction could be the ideology of the parties not always thinking about the dispute as thinking about why you, not me question. So that was my point. Thank you.
So not which seat is better and not which institution is better, but rather
Yes.
the institution of my country and the seat of my country.
Also, what have been very not logical at the end is that the other party was a French company, and they chose Dubai Center for them. So we don't understand actually why they did that, but one of the
DIAC or DIFC, the LCIA?
No, DIAC.
DIAC, okay.
So not ICC or not LCIA DFC, it was DIAC. And we don't really understand why they chose DIAC, but our point of view could be that ICC is very unflexible rules for them to choose whatever they want. That was one of the things they mentioned, but we don't really understand why till now. And no dispute arises to the extent of my knowledge, so we wish they don't, but if we did, we will know why they want their FC Jackson. Thank you.
First of all, I want to thank all the tribunal for their explanation and the wide knowledge. I feel that I'm very impressed. This is maybe the first time I attend a seminar, but it is very, very interesting. I am Mohamed Abdelrahim. I was ex-lawyer in many famous law firms, and now I'm a freelancer. I have a question regarding the bin-ban agreement to Mr. Girgis. It's regarding the differentiation between the seat and venue. I have some concern in this part. What if after the issuance of an award and a party went to the French courts and the other party preferred to go to the Egyptian court regarding the nullity, and there is a conflict between the two judgment of the two courts. What happens in the execution of any of this, especially the judgment issued from France in Egypt? How can they execute? One of the things that we always think about when we are going to draft an arbitration clause, how can I enforce the award? Thank you.
Take, normally 3 questions, then we give the panel the chance to answer. Bashmahondis Nader.
I'm Nagi Skander. I'm an oil and gas consultant and negotiator, and I'm a mediator with the CRCICA in there. My comment first to Dr. Ismail, which he raised a very important issue about the Egyptian upstream concessions and arbitration clauses in there. And I was privileged in the 80s to negotiate part of it in there with the EGPC, and it was very hard for us to convince EGPC to move from referring to any disputes to the Egyptian courts to into arbitration. And it took us, actually, we are the one who've been pushing, and it came up with the introduction of the first gas rights for the upstreamers. And with the upstreamers or the foreign investors said that the gas business is more complicated than the oil, and now we're not going to, we'd like to have an arbitration, and it came in. But through our experience with EGPC and EGAS, it's not easy to change any word in there. And as you mentioned, because it goes to the parliament for approval in there, and whatever these concessions come out after the parliament approval, it's a law. No one can change it. But this is when it happens that when you have an old versions in there, it's not easy to change it because they say you have to get. So my suggestion in here, because we've been struggling a lot with this, that there should be an open channel between CRCICA and EGPC and EGAS, so that every year you provide them with an update in there about what you'd like, the clauses and all that, to be approved by them, to be the approved wording to the arbitration clause that goes into the concession agreements. And by doing this, you are avoiding that they copy and paste from old agreements. And this is what it happens up till now, they copy and paste. So I think an open channel between CRCICA and EGPC and EGAS with all the changes, because actually some of the concession now, the wording in there, although it's an arbitration, although it's referring to CRCICA, but it's not valid. It's not valid because it's an old, very old, it's requiring all terms 10 or 15 years ago in there. So this is my first one. My second question to Mr. Girgis El-Shahid, which about pricing. And it comes in general for the oil and gas industry in there, because the oil and gas industry and energy have been very much adapted with the pricing fluctuation and the cost of infrastructure. There has always been a lead and lag between the pricing of energy and the pricing of steel that comes later on. And this industry had been, for the last 100 years, had been managed within this fluctuation and uncertainty. But the issue that comes in here that you are facing right now, which about the government part in there, is that when the government is not honoring their payment, it is considered as a force majeure for the developers or not, because this is the issue that can make the developer have a reason for dispute. Because most of the time that when we talk about energy concession or upstream oil and gas, when there's a pricing change and all that, the government will say it's working for me and for you, both sides. You don't want to, when you are benefiting with the high prices, you get the benefit, and when it's low, then you're complaining and would like to have a dispute or arbitration. So to conclude, this is considered that the government not paying, I'm not saying default, but not paying on the time is considered a force majeure for developers or not. Thank you.
Now the panel, if would like to, we'll continue taking questions afterwards.
Okay, I'll go with the last then first on in terms of non-payment. there is a very specific clause in the power purchase agreement that non-payment by the Egyptian electricity transmission company is not an event of force majeure. So it's actually not something to be deduced. It's written there in the power purchase agreement, and this is actually very common in this business, okay? Whether or not you can take that and say it in your lending agreement that I'm not being paid, so this is a force majeure in the lending agreement, I do not believe so. This is a matter of English law. However, force majeure is very restrictive in that, and when the parties agree on the power purchase agreement that it is not, you cannot take it in another contract and say it is. That's a point. On EGPC and the concession agreement, I leave that to Dr. Ismail, but I would want to highlight something, Doctor, that you reminded me of. Actually, most of the concession agreement has two dispute settlement clauses. One is when you dispute with EGAS or EGPC, and one is when you dispute with the government, and that still goes to the Conseil d'Etat. And that actually makes the concessionaire a bit hesitant as to what is actually the line of disputes and the like. In terms of the concessions itself, as far as I recall, throughout my something years of experience, that the upstream concessions, maybe only one or two disputes have gone to litigation. It has been, and I will quote you, it has been managed somehow. The concessionaire wants new concessions, so they want to be nice with EGPC. The EGPC is also sometimes the carrot and the stick attitude. So I'm not sure if the concession agreements have ever been to full and disputes up to the very end. I would all the time, maybe sometimes instigation of arbitration and notice of arbitration, but I don't recall that an award has been issued under a concession agreement. Going to the point of the two courts now and the confusion, I think the Egyptian courts, if we go to this clause, will not take jurisdiction. There are multiple judgments that can give you comfort that came out from the Court of Cassation that have differentiated between venue and seat. Actually, one of the very first and most famous ones in this regard is that the tribunal, there was an arbitration seated in Paris, seated in Cairo, but so the entire process was done in Paris. So at the end of the day, in the signing of the award, the presiding arbitrator wrote, seated in Paris with his hand like that. So one of the lawyers tried to take this and say that this was not seated in Cairo, sorry. This is not, the people were in Paris, the arbitration was held in Paris all the time. None of them even came to Cairo throughout the process. So we want to annul this claim because they were not seated in Cairo. They only wrote it that by handwriting, and the Egyptian court respected the concept that there is something called venue and something called seat, and seat gives the jurisdiction of nullity to the state courts. Thank you.
So maybe just a couple of things, and I agree with everything that has been said. Just in terms of the force majeure things, so being qualified in France and in England as well, and being therefore a bit schizophrenic as a result. I confirm that English lawyers, as you may know, are sometimes very harsh. So it's either it's in the contract or there's nothing. So therefore, in terms of force majeure clauses, you have to be very careful in the way you draft your force majeure clause to make sure that any event which you may wish to claim is a force majeure event is clearly defined in your clause. Otherwise, you're pretty much in trouble. So apologies for that, but that's harsh life. Just maybe in relation to the question made by the gentleman, maybe just trying to take it the other way around in terms of the risk of having conflicting decisions between French courts and Egyptian courts. And now, in the case you were talking about, if I understand correctly, it was a Paris seat, right? Now, if you take it the other way around, assuming it would be a Cairo seat, if the award is set aside by the courts of the seat, you might still have a chance to enforce the award in France, because for the French courts, the fact that an award has been set aside by the courts of the seat does not necessarily prevent you from enforcing in France. Just bear that in mind. Sorry?
As a force majeure?
Not as a force majeure, not just as a matter of principle. Yeah. Yeah.
Okay, so regarding the negotiations, I think this was not really a question, but a remark from Mr. Mahdi. Concerning your question, if an arbitration is seated in Paris and then the action of setting aside the award is filed before Egyptian courts, according to the precedents and the constant jurisprudence of Egyptian courts, it will declare that it does not have jurisdiction to decide upon the action for setting aside, because the seat is in Paris or is abroad, and the action for setting aside is brought in Egypt before Egyptian courts. So the courts would decline jurisdiction. But except in one case, if the parties have agreed to apply the Egyptian arbitration law as a lex arbitri, even if they have chosen a seat abroad. This is possible under Article 1 of the Egyptian arbitration law. You can have the seat abroad, but choose the Egyptian arbitration law as a lex arbitri. And in this case, you can file the setting aside proceedings before Egyptian courts. It did not happen before, but theoretically it is possible. So this is another. There is a third information. I have read it somewhere. I've read it somewhere. I speak under the control of Jean-François Le Gall. I've read it somewhere that the French courts would tolerate that, despite the arbitration being seated in Paris or seated in France, that the parties would agree that the setting aside proceedings would be before another court not situated in France. So they would voluntarily change the jurisdiction of the setting aside court by an explicit agreement. The French courts would cease to have a jurisdiction in this case. I've read it somewhere, but I don't know. I don't have the I can't remember where, and I don't have the case number or the reference.
But was it a real case which actually happened, or is it like more like a theoretical?
But I have read it. I have read it. Yes. So I said to myself, it's same as the situation in Egypt. You can have an arbitration seated somewhere, but the parties agree that another jurisdiction would be competent to decide upon the setting aside proceeding. But this is really rarely happens in practice. Wherever you have a seat, this means that the courts of that seat would have jurisdiction to decide upon setting aside proceedings. Regarding force majeure and payments of monetary payments or obligation to pay a certain sum of money, you have to distinguish between force majeure as provided for in the law. So there is the force majeure as a concept in the different codes. So it is usually an event that is unforeseeable and that cannot be prevented. This is force majeure under the law. But also you find in contracts a contractual regulation of force majeure, which may differ from what is provided for in the applicable law. As since force majeure can be exempted from under the law, so the parties are free within their contracts to regulate what is force majeure and what is not force majeure otherwise in their contracts. So that was a remark. Another remark, the obligation under Egyptian civil code, an obligation to pay a sum of money, you cannot be exempted from it by invoking force majeure, because either you will pay voluntarily or you will be forced to pay through compulsory means of being paid. So either you are in insolvency and you can't pay, so your counterparty can always sue you and have you pay by force by seizing your properties. So any obligation of for paying a sum of money, an amount of money, cannot be subject to being exempted from by invoking force majeure, but the case is different when you invoke hardship or la théorie de l'imprévision, hardship under Article 147, paragraph 2. This would apply to an obligation to pay a certain sum of money or amount of money. Thank you.
Now we'll take the last group of 3 questions. I have here 1, 2, and 3. So, ladies first.
Thank you very much for a wonderful. Actually, one question that Mr. El-Shahid is missing an answer, which is just if in the example that was mentioned, would it be different if it was an enforcement action? The receipt was the arbitration agreement and the tribunal signed. So this is just one question. If in the case of enforcement, could it be contested on the grounds of breach of the arbitration agreement or something? But my first question is related to the panel discussion was when we were talking about the infrastructure and energy disputes. We've talked about the concession contracts that have the law, $5 billion in FDI in infrastructure, and we saw also a lack of SPVs. Joint venture, I was wondering, ancillary to these trends of infrastructure and energy apply, and then, for instance, the supply chain, the different developers, or the smaller contracts that can intervene in the form of this big infrastructure or energy projects. So I was wondering if from these trends in this study, to what extent would we consider those disputes to create those expectations, etc.
My name is Luqman Qasim. I'm a judge at the Egyptian Conseil d'Etat, and I have a question for Girgis, if I may. In the example you've mentioned of the arbitration clause that was enforced between the parties, was it the differentiation between the seat and the venue? Was it partly motivated by the restrictions that were enforced by the Egyptian government relating to arbitration agreements that involved any kind of state-owned entities? And I have a very small question to Dr. Ismail. There was a law that was issued in 2014 organizing the appeals against state contracts, including investment contracts as well. And there was a very recent ruling of the Supreme Constitutional Court, like a month or 2 ago, that issued that the law was in fact constitutional. Do you think that this ruling, and perhaps favorable ruling in favor of the law, would limit the political turmoil risks when it comes to the oil and gas industry or the energy sector at large? That's it. Thank you.
The last question back here.
For this informative seminar. So I'm Ahmed Nasser, I'm a PhD candidate, and I'm a judge at the State Council. So my question is last part, Ms. Dr. Ismail talking about the CRCICA new version rules. So I have a suggestion or something like that about online arbitration. It will take a role in this new version. So we're talking about a digital transformation in a justice, in judicial authority, something like that. It will be in arbitration as well. Thank you all.
Okay, in terms of enforcement, enforcement is where the money is. So if you have an award, the set aside is only where the seat is. But in terms of enforcement is if your opponent or the entity that was awarded against some monies have assets in the US, you will have to go to the US courts to get the executor or the likes of the executor in the US to enforce on the assets there. So enforcement should be everywhere, okay? What my colleague here, Mr. Jean-François, has mentioned is that in some unique states or countries, I would say, such as France and maybe the US as well, in certain instances, is that even when a nullified judgment at the country of the seat comes for enforcement, that court of that country will actually look at why the nullity happened, and when the court of that enforcement is not convinced, they will continue with enforcing it. For example, in Egypt, there was an award in oil and gas, actually, downstream concession that had an arbitration clause. That arbitration clause was litigated pursuant to, and an award came to the investor. And then it went to the Egyptian Court of Appeal, and the Court of Appeal said, the deal, this is a utility contract, it has a ministerial approval, it should have had a ministerial approval, hence nullified, okay? The investor took this award and managed to have the executor from the French courts. It went to multiple French courts at the end, but then it went to finally to the Paris court for the executor. But at the end of the day, the French court said, I'm not convinced of why it has been nullified. I don't think it should have been nullified, so I will enforce it in my country at least. Oh, okay, but
I think what Audrey has mentioned is what is written on the award. The arbitrators, they have to write the seat and not the place where they sign the award. Is that your question?
Yeah.
Egyptian courts be inclined to treat this idea of the tribunal signing the award at a different seat than the one chosen by the parties as a ground not to enforce?
The rule of enforcement and even the article under Egyptian law and enforcement, it is different than the article and the rules on set aside. So in case of enforcement, the Egyptian court will look at the parameters of when to not accept enforcement of a particular award. So imagine exactly that Cairo Center case seated in Paris, the nullity then it's a matter of nullity in the Paris courts, and then this award needs to be enforced on assets in Egypt. So the Egyptian court here needs to give the seal, and the parameters that to look at is the parameters of enforcement and not of nullity at all. There are some similarities, but the bar is much higher in enforcement. For example, in nullity, there is the concept of mandatory rule, but enforcement, there is a concept of public order, and these are actually quite different. So in enforcement, the bar is different, okay? I hope I've answered this question.
Sorry to interrupt, and in the case you have mentioned, yeah, the award has actually been enforced in Egypt, although it was signed abroad because there was a turmoil here and the tribunal didn't want to come here and sign. They deliberated, and even the hearing took place. I think it's the City Stars and the case you mentioned it. So it's but it's a public, everyone knows about the case, and we are talking about decisions of the Cairo Court of Appeal. So it was enforced. Sorry to have interrupted, but it was enforced in Egypt.
Yeah. So the Cairo court actually, because the seat was Cairo, but it was handling in Paris, the Cairo court of nullity on the nullity phase said, no, I will not nullify it just because these people were sitting in Paris. So this is exercise number one, and then came in exercise number two, and then enforce it. But then that court did it. In terms of the SPV and to what extent, this is a very, very important question, and actually a question that goes to the word directly and indirectly, okay? Because you will never see the word directly or indirectly. Any crazy lawyer would attempt to try to define it, okay? Because the more complex the transaction is, the more layers of SPVs you will find. And actually in oil and gas, and please correct me if I'm wrong, you will never find the American ExxonMobil actually having the concession in Egypt with the big ExxonMobil, okay? It will actually have an SPV in Jersey, and then that SPV will own another SPV in Holland, and that SPV in Holland is the one that has the concession agreement in Egypt. So to what level is direct and indirect? This is a lot of parameters and a lot of actually advocacy work from both sides, because it will then relate to the essence of what does Egypt want to protect. Okay. At the end of the day, I want ExxonMobil to remain there, and if ExxonMobil is going to be Chevron, this is what I want to change. This is what I want to have control. And so this is the interplay here. You cannot have a definition of to what parameter. And this is a lot, actually also very important in bilateral investment treaties, because there are a lot of investments in Egypt that are structured whereby the investment is here, the holding company is in London, that London company is owned by a Dutch company, and that Dutch company is owned by an Egyptian family. Is this protected by a BIT of either the UK or Holland? It's a very important question that is now in debate under the realms of the BIT. Restrictions by government on arbitration agreement. The bin-ban contracts were actually signed right after, a year or two after, the award of nullifying an arbitration clause because of the lack of ministerial approval. The power purchase agreement was actually signed by the Egyptian Electricity Transmission Company, okay? So XI, not A, not authority. So it did not require a ministerial approval, but the lenders at that time actually insisted that the minister would approve it. Purely nafkh fi zabedi. They were very afraid of that because it's called company, and company is associated with, at the end of the day, the Ministry of Electricity, that somehow it will happen. And that's why the definition in D as well, what does the seat mean, also was included. And this was not actually driven by, and Tim, correct me if I'm wrong, not driven by the developers themselves. It was actually instigated and negotiated by the lenders, the ultimate financier of all of this project. The constitutional judgment, definitely something very positive. And what has happened and what did the Conseil d'Etat do at the era of post-2011 was a cause of a lot of BIT claims. In Egypt, some of them were lost, some of them that Egypt won, but this is definitely a very favorable judgment to the investment environment. Thank you.
Just one comment about the question raised by Honorary, if I understood the question correctly. I think you basically asked Girgis to answer in 30 seconds the question which is asked in each and every investment treaty arbitration. So I think you did a really good job, actually.
I will answer first the question on of Mr. Ahmed. In our new rules, we have a new provision on online filing. So you can file, I invite you all to visit our new website because it is equipped for that. So you can file your notice of arbitration online. And we will be dealing with this in our new rules. Also, the arbitral tribunals will have more flexibility in terms of the use of technology in arbitration and the decision to hold virtual hearings instead of physical hearings. So this is how the new rules are dealing mainly with technology. Thank you. Certainly, the decision of the Constitutional Court is a very positive development. So to summarize, for Jean-François, our guest, after 2011, the Conseil d'Etat was subject of dozens of cases filed. The cause of action was to annul and avoid many investment contracts concluded 10 years before based on allegation of corruption. Based on allegations of corruption.
And filed by laymen or laywomen. You are someone in the street.
Any person walking in the street can go and representing the interest of the society and could file a case. Mr. Sabri, many people and others. So I even forgot their names, but they were yeah. So we had dozens of cases, and many decisions avoided or set aside or annulled existing contracts, or even administrative decisions adopting these agreements. So how, even if these administrative decisions were issued more than 90 days ago, so because they were considered not even null and void, but inexistent, because there was corruption from in the eyes of the plaintiff and sometimes in the eyes of the administrative court. So since this was very negative and very harmful to the investment climate, and was going to expose Egypt to exit cases and investment arbitration cases, so a law was passed in 2014 whereby these actions, if they are based on corruption, they can only be filed if the public prosecution and the criminal judiciary authorities, if they investigate and they find that there is a case of corruption, then you can file a case to request to set aside or avoid the relevant or the related contract. But insofar as there has been no criminal investigation, or the criminal investigation did not find that there is corruption, then you cannot exercise your right to sue these parties to the contract. So there has been a challenge to this law and before the Constitutional Court to declare that it is unconstitutional because it limits the right to sue a person before its natural judge. But the Constitutional Court finds, according to its constant jurisprudence, that the right to sue can be regulated. So this, of course, decision is a very positive one. But if there is a revolution, or there is a whatever, not necessarily here, but anywhere else, the laws changes and the rules of the game, they change, and this usually brings disputes and investment arbitrations if a lot of bits are signed. But certainly the decision of the Constitutional Court is very favorable to the investment climate. I think we have replied to all the questions. For me, I have nothing more to say, and I give the floor to our dear ambassador.
Thank you very much, dear colleagues, panelists, for a very interesting, very enlightening seminar today. As you can see, the title, International Arbitration Trends, there is a lot of trends. We have been with them driving in a path full of legal details, technical details. What we can learn from this, from my point of view, that as far as Africa is concerned, we are in a phase with the larger intra-African trade, which will lead certainly for larger arbitration cases and disputes. Energy is one of the most important era of conflict in the years to come. Political situation internationally or internally have its large impact on all this. So there is a very large spectrum of working and thinking and see what we can do and benefit in the next from this. I would like to thank the three speakers, Jean-François Legal, Girgis El-Shahid, Dr. Ismail, Selim, and I would like also to thank you, the audience, for a very constructive interaction with the podium. Thank you very much. And before concluding, I would just like to mention that we still don't know if we will organize a Wednesday one in April or not, because due to the months of Ramadan. But some ideas are in mind that we are still discussing, and we'll let you know on due time. Thank you very much. Thank you.